The professional responsibility question from July of 2006 is another unusually difficult essay question. Take a look at the call of the question. It reads, "What ethical violations, if any, has lawyer committed? Answer according to California and ABA authorities." We'll see that this question is hard for a couple of different reasons. First, it's another question that we have to organize all around the facts because the law doesn't really give us a good foothold for organizing what's going on here. Secondly, this question is hard substantively because it is testing two different respects in which there are material differences between California and ABA standards. And if you are not sharp on those differences, it's impossible to do a really good job on this question. But it turns out lawyers' conduct is so poor that it falls short of both the California and the ABA standards by a pretty wide margin. This is a lawyer who's basically up to no good from the very beginning right through to the end, and nothing good is going to come of it. Take a look at paragraph 1, and we learn about this lawyer and the client. And we find out a lot of facts about their agreement, both their written agreement and their oral agreement. The written agreement is satisfactory, but if we really get into it carefully, we see that it is satisfactory in California, but it would not be satisfactory under ABA standards. That's just a black-letter law distinction that one either knows or does not know. But under either California or ABA rules, the lawyer may not support the client with an expectation of recouping that money from an ultimate settlement. At the end of paragraph 1, we learn about the failure to disclose where the lawyer has already made a deal with the physician, the treating doctor in the case. Then in paragraph 2, we find out that there actually is a strong legal defense to the case, and so plaintiff's case has less value than lawyer thought it did in the first place. But look more carefully at what's going on. Lawyer now has a financial incentive to settle this case quickly because his monthly expenses are pretty high. So, client, it turns out, in paragraph 3, not surprisingly, is reluctant to accept the offer. Now, what does the lawyer do? My reading of the facts is that the lawyer basically date rapes his client, gets her drunk, and talks her into settling for the deal. But it's worse than that. Not only does the lawyer mishandle the client in a literal physical sense, but the client and the lawyer agree together that they're going to cheat the doctor out of the doctor's fee on the case. So they agree that the client is going to keep the money that the lawyer is able to make settling the case, and they're going to pay the doctor nothing. Well, what a big ethical mess this question is. The lawyer basically doesn't do anything properly, and we are called on to identify any ethical violations. Well, how are we supposed to organize this question? Since we don't really have law to organize around, our other alternative is to organize around the facts. Now, turn and take a look at the outline of issues that I have presented, and you'll see it is one of the least deep outlines to any question that I have written an answer to over the last 20 plus years. And I go chronologically through the facts. First, I begin with the fee agreement. It seems that this is the most complicated part of the case because we have a written agreement and an oral agreement, and there's a significant ABA California distinction. The American Bar Association rules require a lot more detail in the agreement, and to be honest with you, I think the ABA standard is wiser for all concerned. But our editorial opinions about the wisdom of the law are not really being tested here. It's our knowledge that's being tested. And if you didn't know this little wrinkle before handling this question, you know it now. And it's one that easily could be retested, as many issues in professional responsibility are tested over and over again. Well, how do we organize the remainder of the question? I just go chronologically. I discuss lawyers' work on client's case and the duty of competence. Then I talk about the lawyer's seduction of the client. Then the breach of contract with the doctor, and I conclude. So we see there's very little structure to this outline. I don't have a lot of elements of legal principles to hang my analytical hat on. So have a look at the answer that I write, and to some extent this may be one of the more instructive answers that I present, just because in some ways it is so different from many of my other answers. When I can organize an answer around elements like duty, breach, causation, damages, and defenses, or formation, defenses to formation, breach, defenses to breach, remedies, defenses to remedies, it's much easier to come up with a reasonable analytical framework. But for a question like this, one has to go deeply into the facts and take a look at my approach to answering what I think you probably will agree is the most complicated part of the question, the part about the fee agreement. You'll see up front, as often is the case, I lead with the facts, but then I go straight into identifying what the issue is and indicating that California and the ABA both have a take on it. I go into depth with regard to the written agreement, and here, if you don't know the law, you really don't have nearly as much to say as you would otherwise. So, what does one do when faced with a question like this? You have been asked about both California and the ABA. But I don't think you need to be a genius about ethics to see that this agreement really isn't good enough, just because of the oral agreement. So, clearly, the agreement violates both California and the ABA standards as a whole, and being as explicit about that is helpful. But to really nail this part of the fact pattern in a good answer, you need to get into the fact that the document didn't specifically explain the method of calculation, expenses to be deducted, in this case the doctor's fees, and whether the contingent fee is calculated before or after expenses. The ABA's rule on these fee agreements is very structured, and I think you'll agree it's quite reasonable. This is not a disincentive to litigation. This is making more explicit the relationship between plaintiff and plaintiff's counsel. Moving on to consider lawyers' work on client's case, this is a section that many people would tend to leave out. And I suggest that the duty of competence ought to be fairly close to the top of one's considerations of the conduct of any lawyer and their behavior. So I look at what the lawyer has done here, and as far as I can tell, much of it is competent. But all of it is tainted by the fact that he's got this unethical agreement which gives him a financial incentive to get out of the case. And what his client needs is zealous counsel. So I move on in part 3 to consider lawyers' seduction of the client. And here, again, I lead with the facts, and I get into another black-letter law distinction that one really ought to know. And that distinction is that the ABA essentially has a blanket prohibition on a romantic relationship between an attorney and a client. To put a slightly finer point on it, these relationships that are pre-existing do not make it impossible under the ABA for an attorney and a client to have a business relationship. But a non-sexual relationship, that is an attorney-client relationship, is not supposed to become sexual during the course of representation, according to ABA standards. Now, California's rules are a lot more liberal. They basically say, do whatever you feel like, but if your relationship compromises your legal representation, that's an ethical violation. Now, in this case, I think it's impossible to imagine a more drastic black and white violation of these ethical principles, either in California or under the ABA standards. Here we've got an injured PI client reluctant to take a low-ball offer, and what she gets from her counsel is an extra bottle of wine and a romp in bed. And it seems to me that it is hard to imagine an easier set of facts to level ethical criticism against a lawyer. But take a careful look, and you'll see that the 4 little paragraphs that I present in this section go into a lot of sharp analytical depth. You'll see an appropriate balance here between facts and law. Remember, I'm the guy who always says, don't put boilerplate in your answers. And I also say, don't just copy facts into your answers. legal analysis is the art of expressing yourself in a way that a disinterested reader is able to see that you appreciate where the law and the facts touch one another. And I think that what I write in section 3 of this answer is a pretty good example of doing that. Turn to part 4, lawyer's breach of contract with the doctor. Here, I tie in the fact from the very end of the first paragraph of the fact pattern to the parts about this contract after our little seduction scene. It seems to me here obvious that this lawyer is committing an ethical breach at the same time he is committing a breach of contract. And here, there are no subtleties between California and the ABA. What the lawyer's doing here is just wrong. It's wrong according to the ABA, it's wrong according to California standards, and it would be wrong for anybody else to do this. It's just a willful breach of contract done in bad faith. Finally, take a look at the conclusion that I write at the very end of this essay. It's one of the longest conclusions that I present in any answer in this course. And I think you'll see that it is a very sharp conclusion. It sums up exactly what this lawyer did and precisely what is wrong with it. This fairly long conclusion, several sentences long, is a direct answer to the call of the question. And that wraps up a consideration of what I think you'll agree is a challenging and interesting professional responsibility fact pattern.